I'll just start by introducing myself. My name is Matteo Rava, and I am a Senior Policy Officer in ESMA, and I'm leading the work on the integration of sustainable finance within MIFID II. I'll go directly to today's presentation, just at the beginning to confirm, of course, the great importance that the EU co-legislator and ESMA are putting on the work on sustainable finance, which, as you see recapped in this slide, is a multi-year project. So, of course, when you read the consultation papers that we have published on the topic, you should always keep in mind, again, that they are one piece of the big puzzle and should be read together with all the ongoing work streams that both the Commission and ESMA are leading at the moment. Again, just to put the consultation papers a little bit in context, I would underline that they are closely linked to the action plan on sustainable finance that the Commission has published in March 2018, and more specifically, they are clearly linked to the actions number 4 and 7, which are linked to the incorporating sustainability when providing financial advice, and also to clarifying institutional investors and asset management duties when providing services. Going specifically to the request technical advice that we received from the Commission, was received on 24 July 2018 and was directed both to us as ESMA and to our sister authority EIOPA for the insurance part. As you can see from the slide, and I'm sure you're aware of it, it covered the request for technical advice covered many pieces of legislation, MIFID II, IDD, UCITS, AIFMD, Solvency II. And within these pieces of legislation, it also covered various topics. I will just present very briefly the part on the left, so the work we're doing on MIFID II. So we have developed in the consultation paper, again, in order to answer the request for technical advice, some advice on the first topic is that of organizational requirements. That meant for us providing some draft advice at this stage on the topic of the general organizational requirements, but also on conflict of interest. We also provided some draft technical advice on the topic of risk management for investment firms and credit institutions providing investment services. And finally, on the topic of product governance. On product governance, I would just like to underline that, of course, we are fully aware of the big implementation cost and work that industry has put into, of course, the application of MIFID II already in January 2018. So in our draft technical advice, we have tried to be as focused as possible in order not to revolutionize the product governance framework, but simply to amend it in a focused way where needed in order to incorporate the sustainability risks and factors as suggested by the Commission. Always on product governance in the consultation, we also included some suggested amendments to the level 3, so the product governance guidelines that ESMA had already issued in the past. And same thing goes with the topics of suitability, that here you see in a different color, just to underline that we did not receive a request for technical advice on suitability from the Commission, because that work was done autonomously by the Commission itself, but we have just done work on the guidelines instead in order to keep them aligned to the level 2 that the Commission has already implemented. And I would pass over the microphone to my colleague Kiev for the part on the UCITS side.
Thanks, Matthew, and good morning, everyone. So my name is Kiev Navid, and I work in the investment management team at ESMA. So our team covers the fund-related aspects of the work, which is discussed and developed within our investment management standing committee, IMSC. And to take maybe a small step back, the impact assessment report that came with the Commission legislative proposals in May, they suggest that the integration of sustainability risks is currently not a common practice in the industry. And one of the main reasons that they identified in this impact assessment is that integration is hampered by the existing legal uncertainty as to the regulatory expectations from relevant financial market participants. So the Commission mandate that we received by the end of July last year is asking ESMA to provide technical advice on the legislation that is within our remit, so mainly MIFID, for which my colleague Matteo is responsible, and the relevant standing committee colleagues, and the fund legislation to UCITS and AIFMD level 2 frameworks. And in this, in our area in the fund legislation, we were asked to cover 3 aspects of the organizational requirements that you see here, the operating conditions and the risk management rules. And with regard to organizational requirements, the purpose of our work was to clarify that authorized fund managers need to consider sustainability risks and factors in their organizational procedures, systems, and internal control framework, so to ensure that they're properly taken into account in the decision-making processes. And in particular, we also amended relevant provisions to ensure that fund managers give due consideration to the required resources, the expertise for the integration of sustainability risks and factors. And the draft technical advice also clarifies that the integration of sustainability risks and factors is the responsibility of senior management. With regard to operating conditions, the draft technical advice, can everyone hear me in the back also? Louder? Yeah. Better now? Okay. So with regard to the operating conditions, the draft technical advice in particular aims at clarifying that the fund manager should also give consideration to sustainability risks and factors in the due diligence processes. So to that respect, we are proposing to clarify the legal provisions in the Level 2 frameworks. And with regard to risk management, what we're proposing to do is even closer. Wow, okay. Now better? Yes. Getting really close, okay. And with respect to risk management, what we're proposing to do is to apply an integrated approach. So to consider sustainability risks alongside all other relevant risks such as credit risk, interest risk, and market risk. Yeah, these are the three areas that we're covering. I think if we move on to the next slide, you will see some information on the timing. But before I move to that, I think with respect to these three areas that we're covering, what we're proposing to apply is to apply a high-level principles-based approach. This is to ensure, on the one hand, that the legislative measures that we're proposing, they find the right balance between an effective incorporation of sustainability risks in your Level 2 text, and then in the operating frameworks of fund managers on the one hand, but on the other hand, we wouldn't want to propose a legislative framework that is overly, I would say, inflexible and prescriptive. This is a relatively new area, so we don't actually want to propose legislation that would stifle innovation or further investments into sustainable projects, which is the main goal of this initiative. So our proposals, as you might have seen, they're based on this principles-based and high-level approach. Another challenge to manage is the terminology. If you read our consultation paper, actually I think our first question relates to the terminology to be used in the problems related to that. You know that the Commission work on the taxonomy is ongoing, so we didn't want to actually interfere with that, but nevertheless there is an issue that some of the terminology to be used is still not fully clear. So what is sustainability, what is E, what is S, what is G, what are risks, what are factors, and a lot of related questions. So we saw merit in flagging this question also to you to get some steer from you and some feedback from you on how to deal with the situation and how to understand these notions. And then coming maybe to the biggest challenge of our work, the timing. So you see it on this slide. As I mentioned, had only a very limited time. So basically, we received this request from the Commission at the end of the summer break, and so we had a couple of months to prepare this consultation paper for you, and therefore please apologize that the consultation period was relatively short, only 2 months. So the end of the consultation is at the 19th of February, and we're very much looking forward to receiving your input. After the consultation period, we will have another 2 months basically to finalize the work and submit it to our Board of Supervisors in order to meet the deadline set by the European Commission, which is the 30th of April. I think with respect to the ESMA guidelines on MIFID II product governance, Matteo, maybe you want to come in because there's a different...
Yes, just a small but we think important clarification to make. As I mentioned, we're working in parallel on the technical advice and on the update of the guidelines. But just to be clear, our plan is to finalize in April the technical advice, but instead we wait for the final level 2 to be finalized by the Commission before we publish the updated guidelines. This means that in April you will see only the final report on the technical advice, but for the final guidelines it's likely that you're going to have to wait at least probably the end of the year, again because we need to see what the shape the level 2 will actually take before we finalize the guidelines.
Excellent. Maybe one or two final notes. So another aspect that we've been expressly asked to do is to ensure proper coordination between us and EIOPA. As you know, EIOPA is also a mandate here to cover the aspects relating to the IDD and Solvency II. And here, I think this is a key focus of our work, and there are regular calls going on between us and the EIOPA colleagues. I think we need to bear in mind that these are quite different sectors, so we will not have an outcome that will be line by line identical. These are to some extent also different legislative frameworks, but ultimately our goal is to ensure consistency, and therefore if you have any comments on that, please feel free to flag this to us as well. And the final note is on the, we included a preliminary cost-benefit analysis in the consultation paper. This was also done to trigger some reactions from your side and to get some input from you that we could use. So we're very much looking forward to receiving some further input from you on this. So if I move on to the questions, I think we have a lot of questions to you and a lot of areas where we're looking for input from your side. I think roughly these are falling into three categories. So comments and input that you have on the draft technical advice on MIFID II or UCITS and AIFMD, and then also comments and input on the proposed changes to the MIFID II guidelines on product governance, and then also if you have any input for us on the cost-benefit analysis, that would be very much appreciated.
Thank you very much, Matteo and Kian. So I suggest we are opening on the floor, and we have one of our colleagues here who is staying with the microphone. So I would kindly ask you that you mention your name and the organization you are representing. I hope that everybody's fine with that, but in the public hearing, you know, it's all recorded. I have to mention this for data protection reasons. So the floor is yours.
Good morning, Stan. You hear me? You hear me?
Yeah.
Okay. Stan Dupré from 2 Degrees Investing Initiative. I was part of the Edge leg and actually the one drafting the recommendation on the evolution of the suitability assessment test. I've got a couple of questions on that. So the consumer surveys we reviewed and actually conducted ourselves suggest that there's about 70% of retail clients that have non-financial investment objectives. And our analysis of the existing text, both the regulation and the guidelines, suggests that the financial advisor are requested to ask about the investment objectives, and it is defined broadly, which means that we don't see any even footnotes that would exclude non-financial investment objectives. If you look at the result of mystery shopping visits, there's basically no question asked on non-financial investment objective by financial advisors, ever. I mean, we didn't see any, like a retail bank, for instance, that have these questions. And so our analysis suggests that there's currently non-compliance with the existing text, irrespective of the change that will be introduced by the Commission. So I would be interested to hear your views on that and the result of your own legal analysis on the topic. My second question is, like, if non-financial investment objectives are introduced in the suitability assessment test, the result of the consumer surveys shows that, like, most clients want to make a difference with their money, like use their influence as an investor to change the decision-making process in the real economy. And if you look at the existing SRI products, only a very, very small subset of them are designed to deliver those outcomes. The conclusion is that there is a big risk of mis-selling if those questions are introduced. And so my question here is, do you conduct your own consumer surveys and focus group to be able to inform the guidelines you will develop on that? And what is the level of granularity of the guidance you plan to provide? Our understanding being that they should probably be very granular to avoid this risk of mis-selling.
Yeah, I think we'll take a few questions and then come back. Thanks.
Good morning, I'm Sara Lubisodo, from the Italian Stock Exchange and also a member of the technical expert group on sustainable finance.
Yes.
Can you hear me now?
Yeah.
Better?
Yeah.
So my question is about the definition of scope of ESG risks across the two consultation papers. So the one on MIFID II and the one on UCITS and AIFMD. In the first one, the definition is a definition of impact. So ESG is taken as making a positive impact, and there is a specific link with the taxonomy. In the paper on UCITS and MIFID, it's about ESG integration. So I think there should be probably consistency across the two. And I'm a bit worried that just limiting to impact the scope of the MIFID II Level 2 regulation might restrict too much the field, and also create too strong a link between this piece of regulation, this piece of the action plan, and the taxonomy, which is under development.
Hello, Andreas Schlitzke from EFAMA. Maybe two comments. One first would be that we actually quite like this idea about the high level principles that you're trying to integrate, especially when we see the wider issues about taxonomy and all this still being discussed, we're not quite knowing where we land on this. The second point of question would be, you already have this in your presentation quite well, where you say the actual suitability part is done by the Commission without it's not being packaged by it. Can you make sure that the outcome of this will actually be timed at the same time? Because we hear rumors that the Commission might want to release this earlier than waiting for your mandate on the other part. So I think it would be very important that all those changes to the level 2 would come at the same time.
So I'll start by thanking you and giving some first reactions to these comments. I'll start from the first ones made on the topic of suitability. First of all, I would like to thank 2 Degree Investing because they did a very interesting work that I think was key in starting a lot of these sustainable finance initiatives from the Commission. So we read very carefully all the work that you have done in the past on this topic, and which was useful for our work. Specifically on the points you raised, we feel that, as 2 Degree Investing said, but also the Commission acknowledged, sustainability should have already been considered, we say, implicitly by intermediaries, of course, when acting in the best interest of the client. However, the Commission itself realized that this was not probably clear enough in the legal text, and that is why they asked us to modify the legal text in level 2. And I think what you have identified is one of the lead causes of why intermediaries were not asking those questions to clients. So in relation to what kind of supervisory actions we have in place, I think we need to wait first that the our technical advice is taken on board within the level 2, and then to see actually how firms are actually taking this into consideration in order to update their procedures, update their questionnaires, and actually collect the information from clients, which is key in order for all this sustainable finance things to work. I'm afraid that at this stage, any supervisory work that we could do on this topic would only confirm the information that you have already gathered, i.e. that this was, let me say, not completely covered by intermediaries or covered very, very little for clients. And we hope, of course, that thanks to the legislative work that the Commission is doing, and also to the advice that we're giving, this will change in the near future. With regard to the issue of clients wanting to make a difference and ensuring that the products that they buy actually help them reach these objectives, I think that the work here is more in the Commission's fields than in ours, because again, as you perfectly know, the Commission is clearly working on the taxonomy, on the labeling of products, and i.e. deciding when would a product have the right to issue a label saying that it satisfies these objectives. And so we have not been involved. We're sort of observers of that work, so we're not leading on that, and we don't actually have, as you know, any direct supervisory powers on firms. So at this stage, we recognize that the issue. We know that the Commission is working on it, and we can only agree with you on the importance that the labeling work is done correctly in order to ensure that there is no mis-selling, in order to ensure that clients actually are able to buy the products that best allow them to reach the objectives that they want to reach. With regards to the definition of ESG risk, then I'll also ask my colleague Kian to jump in on this. I think our starting point was that the mandate that we received asked the ESAs to integrate the ESG risks or the sustainability risks in the processes and procedures, but did not actually provide us with a clear definition of the scope. So I think I can say quite transparently that of course we discussed internally on the need and on the usefulness of having a clear definition, but we thought that in the short time frame that we had for the development of the consultation paper, and most importantly on basing ourselves on the consideration that any definition that we could have drafted would have needed to be applied not only to the MIFID sector, to the UCITS, but even in a more broader context, even to the IDD, to the Solvency II. So if a definition is developed, it needs to be a definition that is valid for all the sectors, banking, insurance, securities, for all pieces of legislation. So rather than doing a rushed work and just coming up with a quick and dirty, let me say, solution, we prefer at this stage still to keep the issue open. However, we are very keen to have your input on this and suggestions, and if you feel there is a need for a clear definition, or if you even have concrete suggestions of what these definitions should be, we're happy to consider them. Then I don't think we as ESMA could at this stage, let me say, impose the definition, but we could relay the messages to the European Commission when we deliver our final technical advice. Again, I don't know if my colleague here wants to add anything from the UCITS part.